hearing of the Senate Education and Employment References Committee's inquiry into corporate avoidance of the Fair Work Act, and I welcome you all here today. This is a public hearing and a Hansard transcript of the proceedings is being made. The hearing is also being broadcast via the Australian Parliament House website. Before the committee starts taking evidence, I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. The committee generally prefers evidence to be given in public, but under the Senate's resolutions, witnesses have a right to request to be heard in private session. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will then determine whether it will insist on an answer, having regard to the ground on which it is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera, and again, such a request may, of course, also be made at any other time. I'd also ask witnesses to remain behind for a few minutes at the conclusion of their evidence in case the Secretariat staff need to clarify any terms or references. I remind people in the hearing room to ensure that their mobile phones are either switched to silent or switched off. And I now welcome Mr. Terry Gray and Mr. Tom Newmere?
Newmere.
Yes,
that's correct.
Representing Griffin Coal. Information on parliamentary privilege and the protection of witnesses and evidence has already been provided to you. For the Hansard record, will you now please state your full names and the capacity in which you appear before the committee today?
Thank you, Senator Marshall and other senators part of the committee. My name is Terry Gray. I am the Chief Operating Officer of Griffin Coal.
Thank you.
Thank you, Senator Marshall and senators. My name is Tom Newmere. I'm the Support Services Manager for Griffin Coal.
Thank you, Mr. Newmere. I now invite you to make some opening remarks to the committee, and at the conclusion of those remarks, I'll invite members of the committee to put questions to you.
Thank you, sir. First of all, if I could say thank you very much for the committee giving Griffin Coal an opportunity to put its case forward to you. Just as a little bit of a background, I have been involved with Griffin Coal since January of 2015. I came initially just to look and see what was able to be done after the Karna issue. After a number of visits, I started with Griffin Coal in December, having visited the site a number of times prior to that, and in November of 2015, I was appointed as the General Manager. I had a watching brief before that. During the period 2015 through to 2016, we did a number of initiatives on the site, just trying to understand how we could bring this contract round that had historically lost a significant amount of money, and in fact up to 2016 the contract has to date lost in the order of $300 million. That is basically operating costs. That has nothing to do with the acquisition cost. I just want to make that clear to the floor. One of the issues that we found was that at the time we came and when we looked at the costs, the Griffin Coal was in discussions with the AMWU. Their EBA had expired, and I joined those discussions around about November, December of the time. At that time, Griffin Coal had, I think, had up to about 40 meetings. In total, during up to December, they had about 47 meetings with the AMWU. The issue in terms of the Fair Works was that after having these meetings and coming to a stalemate, it was agreed between the two parties that we would engage Fair Works to see if they could mediate a meeting, and those meetings started in January of 2016. I think it's fair to say that during that period, we've been working on a whole range of cost-cutting exercise. But it became apparent from an early stage that labour was one of the significant issues that was there, and given the view that there were a lot of areas that we could attack, that it became essential, in our view, that we were able to address the labour costs as part of an overall plan to bring sustainability to the company. The plan, in essence, was threefold. In the first main, it was to do with stability, to stabilise the business, because it had just come through the Kana era. And so one of the things that we did was to, on the back of our presence, was to attract investment in order to invest in equipment so that we could get the equipment up and running and we were able to satisfy our clients' requirements going forward. That was the first part of it. That has essentially been done, although there's a lot of outstanding work to be completed. The second part is the sustainability effort, which is the much more harder part. That's actually bringing the business round to what we believe is a break-even situation, not to a profitable situation, but to a break-even situation where the business was not reliant on investment or inflow of funds from the parent company. So these things have happened. One of the difficulties we had with the enterprise agreement was that there was very little flexibility in the enterprise agreement. The salaries that they had in the enterprise agreement were significantly higher compared to what the business could afford. And obviously, in an attempt to try to offset those losses, we had a lot of negotiations with the AMW to reduce that. Clearly, our strong preference is to have an agreement with the unions and to take this business forward. We understand quite genuinely that the scale of the change that we're asking the employees to take is significant, that it does create a significant financial on-cost onto these individuals, but it is, in our view, a very necessary step in order to take this business forward in sustainability. Not to get some consideration on the salaries would mean that Griffin Coal would have to continue operating at significant losses, depending on inflow of funds from the parent company, and that would have a very detrimental on the prospect of Griffin Coal becoming a sustainable entity. I think in terms of the bargaining, we've been very consistent in where we've tried to take this. The issue with the 4-panel roster is basically cost and efficiency. Griffin Coal will only, in the foreseeable future, will only produce in the order of 2.7 million tonnes. One of the contracts that Griffin Coal has is up for renewal at the end of this year, and therefore we have no certainty whether that contract will go forward. And so we have to address costs as being part of where we are. We have implemented or requested the 3-panel roster on the basis that it's more cost efficient. It suits the needs of the business in terms of the production, and it's more efficient. What we've also done is because we've tried to persuade the AMW to have a 3-panel roster, the cost of in terms of the salary, because you have a lesser amount of people, you have an opportunity to pay them a greater and higher amount of salary. I think just in terms of the 3-panel roster, what we'll be saying is that the offer that we've put to the employees at the moment is for a basic salary of $123,000 per year. That would be based on a sort of annualized salary. And for that, they would work 14 shifts of 10.5 hours over a 3-week period. Superannuation would be at the notional rate of 11.5%. In the last offer, we offered the employees a transitional payment because we understood they would have some financial hardship during the period of termination. We offered them a one-off payment of $2,500. Leave entitlements would be 6 weeks of annual leave, 3 weeks of personal leave, and 13 weeks of long service leave. Unfortunately, this was rejected recently. In our view, the termination of the maintenance agreement was an unfortunate but necessary step that had to be taken, because without termination, we would not be able to get back to the position we were before. I'm not very well au fait with industrial relations in Australia, but agreements simply have to be changed to set the needs. If I may say so, the original agreement with the AMW was set in a different environment. In 2011, as you know, the coal prices were very high. Lanco had an expectation that they would be able to put in infrastructure, that they would be able to export coal up to the order of between 15 and 17 million tonnes of coal per annum, that the domestic market would be sustained to around about 4 to 4.5 million tonnes, and I guess those terms of that agreement were set in that light. What in reality happened was that the export market did not materialize due to external issues, and therefore Griffin had to sustain itself just with the domestic market and had to also sustain those losses of $300,000 that I explained to you before. What we're trying to do now is basically reset the business.
Sorry, Chair. 300,000. You mentioned a figure of 300 million earlier.
Beg your pardon, sir. 300 million. That's my mistake. 300 million.
So it's 300 million.
300 million, sir, yes.
Thanks, Chair.
So what we had to do was to reset the business so it can live in its current environment, which we have 3 local contracts. We have to live inside our costs. We are hopeful that we can sustain this business going forward, and that sustainability would be for the benefit of both the company, would be for the benefit of the employees, and would be for the benefit of the community. That's where we are at the moment, and I think we will continue to make our changes. We are still very much au fait in discussions with the unions. We currently are having discussions with the CFMEU in also to ask them to take reductions in salary and also to support the sustainability of the company. I think that's all I'd like to say at this moment in time, sir.
Thank you, Mr. Gray. Mr. Gray, you indicated that you had a bit of a look at Griffin Coal before you took the position. So can I ask where you came from to be in that position? Were you headhunted to do this role?
Yes, sir, you can. I've spent most of my life in mining, either in hard rock or coal mining, predominantly in coal mining. My experience previously was I spent 20 years. I'd spent a number of years. I started out my life as an engineer in the UK. Went to Australia, where I worked on some feasibility plans at the time for Liddell Power Station. In fact, we were talking about opening Liddell Power Station, the mine site beside that. I then went back to the UK until 1993. In 1993, I went to Indonesia, and for a period of time, for almost 8 years, I was the mining manager of TIS Indonesia, looking after all of their mining contracts. And that time, they were doing in the order of about 36 million tonnes of coal per annum over 4 sites, with a turnover of just under $500 million US. I then started a consultancy company in Indonesia at the boom, but by 2011 the market had fallen out of that market, so I decided to close that part of the business, and I had worked through a common associate who had contacts with Lanco and the finance institutions who asked me to come and have a look to see what we could do. As I say, my first indications were very much to be on an improvement basis. But very quickly, when I got to the site and understood the predicament and understand the constraints on the business, it became more of how can we set this business properly to take it forward, not for today, but for the future.
Right. So I'm just trying to picture, so you came in to implement a plan that had already been developed, or you were effectively headhunted in to recover what was there?
Headhunted to recover, sir, yeah.
Yeah.
There wasn't a plan, but the investors were keen to make sure that any investment that was made into the company was spent properly, was spent efficiently, and would form part of a long-term strategy in order to sustain the business.
Okay. So in terms of your experience with Australian industrial relations law, you would have been relying on some advice.
I've taken advice, sir.
Yeah. So who's been providing your strategic advice in terms of your workplace relations?
Kingswood Mallison, sir.
Kingswood Mallison. And are they getting advice from anyone else?
Not to my knowledge.
Okay. So that's the legal side of it. Is there any other any other consultants that specialise in workplace relations that you may be using?
No, sir.
All right. The evidence provided to the committee in Friday in Collie, it was put to the committee that agreement was on the verge of being reached. In fact, I think they used the words that an agreement was about to be put to the membership with a recommendation to support it just prior to the agreement being terminated. Is that your recollection of what happened?
May I have 2 minutes to just give you the chronology as I saw it, sir? Because it is important.
Yep.
As I said before, there were 47 bargaining meetings which I understood occurred between April 15th and December the 15th. As I said, I came on board in November when the indication in the bargaining meetings that there was a status quo, that the AMWU was saying to the Griffin Coal, we'd like to keep our own terms and conditions. That's where we'd like to sit. There had been some offers put on the table for some reductions, but clearly they were not enough in order to sustain the business. In December of that year, both parties agreed that they would go to the Commission to see if the Commission was able to mediate an outcome from that, and that was agreed that they would start in January. Also, because of the financial constraints on the company, and as you can imagine, if they're losing in the order of up to $50 million per year, the company also decided to make an application for termination at the same time, but run the discussions with the AMWU in parallel with the Commission. That was what occurred. The hearing for the termination...
Just before you go on with the timetable, why was that decision made?
Because of the substantial losses that the company was made. The company were concerned that they would not be able to continue going forward if they weren't able to get an outcome with the Commission.
So the purpose of the termination of the agreement was one of leverage in negotiations?
It wasn't leverage, but it was timing, sir. Because clearly, as I said before, the parent company were having to inject substantial funds into the business, and the investors were looking to get some comfort that we would be able to get some outcome. So sitting at a certain side of the table, you may say leverage, but the timing was because of the severe financial constraints on the company.
And before you go back to the timetable, I just want to be clear about the parties agreed to go to the Commission to get some conciliation and mediation.
To get a
but
deal.
But the parties didn't agree to also go to the Commission to have the agreement terminated. No. That was a unilateral decision by the company. All right. Okay.
So in the Fair Works meeting, there were 17 meetings that were held in that forum, sir. When it looked, as I said, so the hearing for the termination commenced in April. When it looked like there was a deal on the table between the AMWU and Griffin Coal, which was the May the 2nd agreement, which was put to the workforce between the 16th and 18th of May, Griffin Coal applied to the Fair Works to suspend the termination pending that outcome. Because Griffin Coal were keen that if we were able to do a deal, we wouldn't have to go to termination. So that happened at the time. But between 16th and 18th of May, the workforce in the maintenance department at Griffin Coal fundamentally, wholeheartedly rejected that deal. So after that, Griffin...
So when you use the words deal, was there a deal between Griffin Coal and...
agreement for a deal for a new agreement, sir.
Right, but a deal between who?
Well, it would ultimately be the workforce vote on it, so it would be a deal brokered by Griffin Coal and AMWU and voted on by the workforce.
I just want to be clear with the terminology. Because when you said it looked like there was a deal on the table, to me that meant a
deal in terms
outcome,
of the terms and conditions that would sit around the agreement, sir.
Yeah, then to be ratified by the members.
It has to be ratified by the workforce.
Yeah, but there was no deal. You were just going to put a proposition to the members.
No, there was an agreement in Fair Works. There was an agreement in Fair Works with the AMWU to present terms and conditions inside an agreement to the workforce.
Okay, And that was then
That
rejected?
was subsequently voted down, sir.
All right, okay. Thank you. Sorry to interrupt.
No,
It's just important that we understand.
It's important we get absolute clarity on this.
Yeah.
So as a result of that being voted down, Griffin then requested that the Fair Works Commission continue with the process. And that happened. And on, if my notes are correct, on the 9th of June, the Fair Works handed down a decision. That was subsequently appealed by the AMWU, but that was then came up in front of the full bench, and I think that was ratified, and the decision was upheld on the 21st of July. During all of this process, sir, we had stated that as a safety net in this process that we would pay the workforce 40% above the black coal award. We were conscious that in the event of a termination, it would create a huge issue with our workforce. We weren't keen to have that happen. We didn't want to, we're not punishing our workforce, sir. We are trying to get them to an accommodation in terms of how can we make this sustainability plan going forward.
The evidence that was put to us is that, I understand what you're saying there, is that they believe you're beating them into submission.
I refute that, sir. Yeah. As I said before, you will see it from two angles. But no, it's never been our admission to beat them into submission, but it has always been our intention to come to accommodation with our workforce in order to take this project forward.
All right. Was it, was the offer ever put on the table or suggested by you, or by you I mean Griffin Coal, that the Commission arbitrate an outcome?
In terms of?
An agreement?
That was his role in that he was arbitrating. He was trying to negotiate a deal between two parties, sir. Yeah,
no, arbitration is that he will make the final, or the Commission will make the final decision.
It was
what you were doing was mediation and conciliation.
Yes, it was using a third party to try and get two parties to come together.
So the question was, so the Commission can in fact arbitrate if both parties agree to arbitration. Was that offer ever made?
No.
All right. So the union had never put to you that they would agree to an arbitrated outcome?
Not to my knowledge, sir, no.
All right. In terms of just the 40%, before I hand over to my colleagues, the 40% that you've put on only goes to the hourly rate. Does that also go to overtime payments? Does it go to annual leave payments, sick leave payments?
It reflects the build-up of the salary rates, but it does not go to the other entitlements or flow through.
Right, okay. All right. So, again, just so we're clear, it's not actually a 40%...
across the board?
Yeah.
40% on the black coal hourly rate, sir.
Just on the hourly rate, but not the hourly rate that would be paid for sick leave, annual leave, long service leave or any other. What about superannuation?
Superannuation was originally set in our original offer at 11.5%. It now defaults back to 9.5%.
Without the 40% loading?
Sorry?
Without the 40%
yes.
loading?
Okay. All right. Just in terms of, so what's the percentage of the maintenance workforce of your entire workforce, roughly? I think we guessed 20%, but I just wanted...
Well, yeah, the numbers are roughly 65 to about 150, so it's just whatever number that is.
Right, all right. Well,
65 to 100, sorry, 65 would be the maintenance number. And we're talking now, sir, about a 3-panel roster, if that's what we're talking about, just to give you the numbers. The workforce, the production workforce would be in the order of 150 to 155, and the staff would be in the order of between 60 to 70, depending on what happens.
So in terms of the working to the award now, are people, how are disputes about that now resolved? Again, the evidence put to the committee on Friday was that effectively, again, without you agreeing to the Commission arbitrating matters that might be in disagreement about the interpretation, it is simply a matter of you saying this is how it will be.
Look, There are disputes that are put in the court, and they are being heard by Fair Works. They are being heard on interpretation disputes, sir.
So in the court or at Fair Work?
At the Fair Works.
Right. And is your position that Fair Work can arbitrate on matters of award interpretation?
Was it that or the court, Tom?
It's for Fair Work.
Fair Works, yeah.
Yeah, so it's your position that Fair Work can arbitrate
on the legal issue, yes, sir.
Can arbitrate on matters of award interpretation. Is it?
Yeah, as far as we know, we rely on the award.
Can I take advice on that, sir?
Sure.
Thank you.
Thank you. All right, Senator Pratt.
Thank you. Thank you very much, Chair. Can I ask, the majority of your maintenance employees, they would have a significant length of service, wouldn't they?
Yes, they do.
Some in excess of 15 to 20 years, would that be correct?
A considerable number, yes.
Can I ask what the effect of the EBA cancellation on the value of their accrued entitlements, such as annual leave and long service leave, has been?
I think before I answer that, I think we have to go to the offer that was made to the workforce as part of the accommodation on the agreement. And as part of that agreement, that those entitlements for long service leave and for annual leave were to be preserved at the existing rate. And they would be expended through the period of time at the existing rates, but going forward, that they would then be accrued at the new rate.
Yes, yes, that would be the usual expectation of how these things
so
operate.
there was a, but in state of the termination, that's a different case. But in terms of what was our intent were to preserve those existing entitlements that they had.
So why didn't Griffin maintain those accrued entitlements after the cancellation? Because you...
After the cancellation, because it would have given the employees a significant amount of other income that would have been less attractive in taking our deal.
No, I think you misunderstood my question. That you'd already agreed that they were entitled to the preservation of their previous entitlements.
On the basis of signing an agreement, yes.
So why didn't you maintain those accrued entitlements after the cancellation? Is it simply because you weren't required to by the decision? Were you expecting the decision in cancellation of the award of the enterprise agreement? I'm sorry, to include the cancellation of those entitlements?
The offer that was agreed for the new EBA had preservation of those rights in that offer. Subject to the termination, they were not paid going forward. That's the timing. The timing was not the other way around, it was that way around.
So the value of accrued entitlements have been ring-fenced in other decisions where EBAs have been cancelled. Were you surprised that they weren't ring-fenced in the case of this cancellation?
Was I surprised? I don't believe I have a view on that.
All right, so you don't have a view on that, but I guess you were happy to...
As I said to you before, in terms of the laws and regulations and the industrial regulations, I'm not up to speed, but am I surprised? As I say, I don't have a view on that.
But you're nevertheless happy to pocket the outcome as a... which I guess you've used to pay off Griffin's debt. Could I return to the...
Excuse me, ma'am, that's not entirely correct. We're not paying off the debt. We are servicing the operating costs. There is
But you've wiped off a considerable liability. You know, those accrued entitlements would otherwise have been sitting in your liabilities column as an outgoing cost that would need to be paid.
Long service leave, you can claim it back. Long service leave you can recover, so that doesn't sit on our books, but we pay it out and recover it. But yes, you are correct. But I would, for the purposes of this forum, just make it plain that any benefits is assisting us at this moment in time in running the company sustainable in the operating cost parameters.
So can I return to my question, which is what has been the effect of the EBA cancellation on the value of the accrued entitlements, such as annual leave and long service leave? Are you able to quantify that for the committee in some way?
The saving, I'm not able at this time, but I would be able to. I would be able to quantify that if that assists you.
Yes, thank you, Mr. Gray.
Is it true there were a number of employees with significant lengths of service who resigned immediately before the EBA cancellation took effect in order to preserve the value of their accrued entitlements?
There were a number of employees who resigned. I mean, people resigned for various reasons. No one came to me and told me that they were resigning for that reason, so I have no view on that statement.
How many were there? Sorry, it's Mr. Gray. How many, when the blue was going on and all of a sudden the EBA was cancelled and it was back to the black collar ward, how many of these maintenance people resigned?
I think above 20, sir.
About 20. And do you often get 20 people resign all around the same time? I was just trying to establish why they would come to you and say they're pretty peed off. That's all I want to know.
It's very unusual circumstances, sir, because we are trying to take a business forward, and we're asking for changes in people's remuneration and conditions, and perhaps at that stage they decided this is a watershed in their life and they'd like to do something different. I cannot comment for them either collectively or individually as to why they did it, but I do confirm that over 20 did actually resign. Yep. Yes, sir. Mm-hmm.
How many maintenance employees are employed at Griffin Coal? Does this include contractors? How many permanent staff, production employees and white-collar employees? I appreciate we've touched on some of this already, but I guess the point is currently you've got maintenance staff, which I understand are the smallest group of workers in comparison to your other cohorts. Is that not correct?
Would you like the numbers, or have you asked for the numbers? Yes. My recollection, again, to be truly accurate, I understand there are around about 44 maintenance full-time employees, and there is just under 30 contract labour.
And production employees?
Production,
and employees?
there are, with a four-panel roster, with a four-panel roster, there are 160 production, and there is, I think there's about 35 or 36 contract labour employees on site.
And white-collar staff?
Staff, there's currently 69 staff. Okay.
But currently the strategy to reduce costs has only targeted the maintenance
No, staff? That's not true. If I could give you some insights into what's happening. We are currently in negotiations with the CFMEU. We are trying to get like terms with the CFMEU in terms of the rosters, in terms of getting salary reductions. And depending on the outcomes of that, clearly we're waiting for the outcome and hopefully being able to do the agreement both with the AMWU and the CFMEU. We would then restructure our staff. I think what is important to understand for the members of the Senate here is that during the period of the last EBA, that as part of that EBA, that the maintenance workers got an increase over the period of 19% in salaries.
Over a 3-year period, 4-year period?
Over the period of the EBA, sir.
Which was how long? What was the length of the EBA? Was
4 years.
You're nodding, sorry,
4
Mr.
years.
Mayor, but we don't pick up nods in hands.
Sorry, Glenn. It's 4 years.
Sorry, 4 years.
4 years.
4
okay.
years.
Yeah.
The CFMEU, their agreement expired, sir, in July of last year. Over that period of time, under the EBA, they got increases of 24%. In the same period, the staff numbers started out as 100 and have now gone down to 69. And those staff members, as part of that period, received no pay rises other than for promotion, sir. So a normal staff person got no pay rises.
You're saying a normal staff person. What is a normal staff person?
Well, I'm talking about someone like a clerk or something
So
who
you're
would...
saying white collar?
Sorry?
You're
Yes,
saying
sir.
you're white collar?
that was
White
my
collar.
question.
I'm just losing what's the link between the CFMEU members that are employed
CFMEU are
and the
production...
AMWU members that are employees of yours. Are they any different? You seem to be answering that. How dare they take a pay rise when the other ones, the white collars, didn't
No,
get it? That's all I'm
the
picking up.
inference...
I don't think that's...
I didn't ask
think
you.
that's
I didn't
absolute
ask you.
misrepresentation of Mr Gray's evidence.
I didn't ask you. That's how I.
Sorry, I'm
Mr. Gray can
trying
answer
to
for himself. He
understand
doesn't need
what
you.
your point.
Yeah, Mr.
I'm
Gray.
merely making the point that Senator Pratt said that the staff, the focus was on the maintenance people and not the staff.
And you were answering it. You were explaining.
Okay, so
thank
in terms of white collar staff, they have not yet been, they've not been subject to the same proportion of salary.
To the
cuts.
best of my knowledge, and that's the information that I've been given, they did not receive any increases in salary over that period of time.
Well, we're not talking about increases here. We're talking about the burden that you have explained to put the company back in a position where it is more competitive, and the disproportionate sharing of that burden currently by one group of workers relative to all other workers at the company.
I think I also said that on the basis if we were able to get an outcome, we would revisit our staff and we would we would revamp our staffing positions as well. But I'm not doing that because currently on the mine site I have the AMW workers that are working on a 3-panel roster. I have the CFMEU who are still working a 4-panel roster, so I have to maintain that coverage. But clearly, going forward, if I can do something different, then we would look at our staffing structure.
Could you explain what you mean by do something different in the future when it comes
think there would
to
be
the
some.
AMWUs?
I think there would be some reductions in staff.
And what do you mean in terms of doing something different in relation to the AMWU employees?
Well, there would be some reduction in numbers.
Still more to come. You've had some reductions, some left.
Yes.
But you've had some contractors. Were they always there, or have they?
No, we don't have.
supplementing some-
We don't have staff contractors, sir. No.
No, I'm just trying to pick up. You said that you would. Sorry, Senator.
No, you're fine.
That there were a number of people who left.
There are a number of people that have contractors. Yeah. Look.
And the contractors have always been there, Mr. Gray? Or
No,
they?
the contractors have only been there, but I am quite happy to share this with you. On the basis that we can get a new agreement, our position is quite clear. We've said to both the AMW and to the CFMEU that we're quite happy that those contractors would be replaced by permanent numbers up to that stage. They're only a short-term expedient until we understand what's happening, sir.
Mm-hmm.
So you haven't yet put on the table any improvement in the current conditions of the AMWU workers, given they have been put back to the award with that so-called 40% loading, which is only so-called because it doesn't apply to everything.
Might you just repeat the question so I understand it?
You haven't yet put an offer back to the AMWU to improve the current reductions that they've experienced, which are fairly arbitrary given they revert to the award.
We did put what I said earlier, which was the current offer on the table, which was made in December. There was an initial offer that was agreed, that was rejected. And then we put an offer on the table on December in order to get away from the Black Coal Award plus 40%. We put an offer to the workforce, which was the improved offer to 123,000, which I mentioned earlier, and that has been turned down.
Okay. So at this point, white-collar staff and management haven't yet had their wages reduced.
No.
And sorry, just to clarify,
Okay.
have CFMEU members had their wages reduced?
Were not able to reduce their wages, although their agreement has expired. who were not under law able to reduce their wages until such time as a new agreement is in place.
So no. Okay, thank you.
Can I ask whether your expectation is the Black Coal Award would not normally have a three-panel type roster attached to it. It seems like pretty new territory to me to have a FIFO style roster attached to an award like that. Are you the collie community is not one that has historically operated on FIFO style rosters, and you'd be very aware that it's pretty incompatible with the family choices that people make in terms of having made the choice to work for Griffin Coal to start with.
Sorry, so what is the question, please?
Well, what is your response to the suggestion that a three-panel roster is incompatible with the Black Coal Award? It's not what any standard negotiating
I haven't seen any evidence or any anecdotal information to suggest that's the case.
Well, people are now working much longer hours.
Yes.
For a substantially reduced pay in a community that's historically been used to not having their dinner served in the outside the donga, but they have to go home and prepare meals with their families, etc. These are fairly extraordinary circumstances that are being imposed by having a three-panel style roster in a community like this one.
Look, they still have a very significant amount of quality time with the family. Again, because perhaps I'm not from Australia, maybe I have different views on that, but what I would say to you is that they, instead of working 12-hour shifts, they're working 10.5-hour shifts, and in a 14-day, in a period of 3 weeks, they're working 14 shifts. So.
Senator Sterle.
Oh, just very quickly, thanks, Chair. So, Mr. Gray, what were these maintenance workers on? What was it an annualised salary or was it hours? Previously?
They were on an annualised salary, sir.
It was all annualised?
Annualised.
What was their average, you took 123?
In the order of 139, sir.
So
139,000.
139. They've now gone down to, what are they now?
The offer on the table, well, they've now gone down, under the Black Coal, it's now in the order of about 115, depending on whether you're day shift, night shift, or day shift. Between 110 and 150.
Well, so we'll compare apples with apples. With 139, what would that equate to that? Hang on, I'm starting to sound like I'm confused here. I'm not. 139 is what it was, but then we've gone to the Black Coal.
139 would be about 114,000 at the moment.
114, okay. Yes, and now there's an offer of 123.
Yes, sir.
Okay, and that's been knocked back very clearly. So how many extra hours are they working now at the 114 as compared to the 139 when there was an enterprise?
They're working 7 hours a week extra, sir.
7 hours a week?
7 hours per week.
Over 48 weeks a year? Yeah.
Yes, sir.
Okay. What changed in the when the enterprise agreement was structured back in 2000? When was it? When they first signed off your management? Signed off the enterprise agreement 2011, was it? 4 years?
2011.
Okay, and then you said something about external issues on the export market. What were they?
There was I mean, I think, as I say, you can't look at it in isolation. I guess you have to understand the ambitions, the expectations, or the assumptions that Lanco made when they acquired this business. The coal market was very buoyant. There were expectations that both China and India would have sufficient capacity to take imports. Lanco, being an Indian company and being in the power business, clearly had aspirations to import significant volumes of coal. As mentioned before, they had a plan, that I've seen, to develop the mine site to have between 15 and 17 million tonnes of export capacity. They also had a view that the domestic market may have risen from the current 2.7 to perhaps 4 million. And so those were some of the assumptions that were made, I would suggest. I wasn't there, so I can't comment. in signing a deal, and also I guess it would be fair to say that at that time that there were a lot of calls on very skilled workers in FIFO positions, and therefore Lanco would have had to compete with those positions in order to sign that thing. So that would be the background on which that agreement would have been signed. That's my view, sir. Whether that's the truth or not, I'm not sure.
Okay, thank you. And I'm very mindful and conscious of the time, so the chair still has some questions, so I'll just wrap it up very quickly. How many contractors did you say? Was it 30-something you have now on the site in maintenance?
In maintenance, we have, I think it's under 30, sir.
Okay, well, let's just say it's 30-ish, around there. And they weren't there before the enterprise agreement was terminated, is that correct?
No.
So why are they there now if we've got the workers, and it's not a set-up question because I honestly don't know. So the workers are working, you lost about 20, but they're working 7 hours per week. Is it week? Yes, it is. Extra. Mm-hmm. So why are there 30 contractors? Is there a lot more work that's come up since the agreement expired? Or?
Because we're still operating, the production still operates under the auspices of a 4-panel roster, 12-hour shift. So these guys are on 3 panels. As I said to you before, the number of permanent workers there is not our optimum number. Right. They are filling in the gap, and I hope, subject to an agreement with the AMWU, that those contractors would be converted into permanent positions. That's the company's position. All right, I get that now. It's very clear in my mind. Some of the people who are reduced, the rosters are have reduced from a 4-panel to a 3-panel. Payments come down about 25k a year, but you're having to supplement your the original numbers when I came to the site, so were 86 in the maintenance workforce initially. Okay, and they've dropped off? Yes, sir. Okay, that's just cleared it in my head. Thank you very much. Chair, thank you.
Thank you. Mr Gray, has the company's negotiating position improved with the termination of the enterprise agreement?
I don't believe so, sir, no. I'm not sure of the thrust of your question, but I don't believe it's, as I've said before, termination was an outcome, but it's not the outcome that we desire. We desire to get an agreement with the AMWU as we desire to get an agreement with the CFMEU, because they are part and parcel of the solution in taking this particular project forward.
Well, if I accept that, and the termination of the agreement hasn't improved your negotiating position, why did you do it then?
Because the agreement, the old agreement, was inflexible and would have stayed in perpetuity if we had not been able to get an agreement. And that is on the back of, as I reminded you, that is on the back of the fact that the company is continuing to sustain at that time significant losses. As I say, I've mentioned the number before. And so that was, if we had never gone for termination and we were unable ever to get an agreement, then it would have been unlikely that the company would have been able to continue trading going forward.
Has the termination of the agreement, in your view, led to a more likely outcome of a new agreement being reached?
I don't believe so, looking at the last result, sir.
So, where do you intend to go now? So the termination of the agreement is simply, in your words, I'm not disputing you, I'm just trying to clarify things very clearly so I understand the outcomes of these events. So you say it wasn't to improve your negotiating position, but it was to remove the terms and conditions that have been negotiated and agreed over a period of time and revert back to the award.
The previous agreement, whilst not being able to be sustained within the cost structure, was also very inflexible as well, sir. So for example, the company was not able to take advantage of market forces or anything like that. So it was a very restrictive contract. So there were other reasons other than the cost issue which was there. If the company goes forward, it has to have more modern, flexible agreements that it can thrive within, but not to the detriment of the workforce. That's not the intention, sir.
You accept that what's happened currently is to the detriment of the workforce, though?
If we're able to come to an accommodation with the AMWU and take this forward, and able to come to an accommodation with the CMWU and get a sustainable project, then that is in the best interest, in my humble view, of the company, the employees and the community at large. That's my view.
Did you take into consideration the public interest of the Collie community before you made the application to terminate the agreement?
I think taking the project forward is in the public interest, isn't it? Or am I missing something here, sir?
No. We can all have views about this, and I have views, but...
You asked me. Did we take...
Well, I didn't ask you to ask
look,
me.
It wasn't,
I asked you to get an answer from you.
I think, as I said before, when you have a view on where you take a project, the project always has the interests of the community at large. Because my view is without Griffin Coal and without that project, then it would impact significantly on the community.
Sure, I hear your answer. The thrust of my question really was, did you try to ascertain in any way with the community about the public or the community impact of a decision to terminate the agreement?
Look, by virtue of the fact that it impacts on the employees, it has an impact on the community, yes, sir. Yeah. But I think, may I finish, sir? I think of greater importance is the fact that the community has people who are employed in the mining industry. So did I take it into account in that respect? Yes, sir, I did.
Okay. So the question was really about, did you take the views of the community? What you've told me is that you made a call on what's in the best interests of the community in absence of asking them. Again, it wasn't a trick question. I was just trying to find out, because the Act talks about the public interest, and I'm just wondering whether in applying for the termination of the agreement, you tried to satisfy yourself apart from, as you've described it, you know, obviously that's your view that you know what's in their interests. I was just trying to ascertain whether you asked them in any way. Because I understand there's groups, isn't there some consultative groups? Is there a Collie community consultative group?
We do attend some groups, yes, sir, but whether they have not come, on the reverse of the coin, sir, they have not come to me and said this is not in the best interest of the community.
Do you go to those meetings?
We do attend some of them, yes.
So you're saying this has never been raised at any of those meetings?
Not in any forum, sir, no.
All right. In terms of I just want to come back to the replacement employees. You've now got, I think, 30 contractors? Did you say maintenance?
In the maintenance department,
yeah,
sir? Yes.
In the maintenance. All right. So what terms and conditions are they employed under?
The same conditions as our maintenance employees currently.
So how does that apply? What legal instrument makes that happen?
We are just paying them the same as their employees at the moment, sir. That's...
You can take that on notice, Mr Gray, if you don't
Sorry?
know the legal instrument.
Sorry, could you repeat that?
I'm just saying you can take your answer on notice if you need to check what legal instrument is.
But we are. My understanding is we are paying them the same, but I'll take notice and come back to you on that.
Right.
Thank you, sir.
So are they employed on individual contracts?
They're employed to a third party.
Right. And they don't have an employee agreement with their third party?
I'm not aware of that, sir. I'll take advice on that. But yes, I presume they will have some terms of agreements with their employer.
Okay. So when the contractors accrue annual leave, that will also simply accrue at a lesser rate than their hourly rate than they get paid?
I'd have to take advice on that, sir.
Right. Well, yeah. Well, if you would, because you did say they're employed under the same terms and conditions.
Oh, yeah. Well, salary conditions, certainly, sir. But yeah, I will check all the
So the hourly rate is the same?
Yes.
Is that all? All right, so you're going to take all that on notice?
I'll take advice on that and get back to you, sir.
All right, then. And if you could find out what sort of instrument they're employed under, that would be good too. Is it simply one third party or are there several?
There's a number, sir, yes.
All right. Okay. Senator McKenzie?
Thank you very much, Chair. Thank you, gentlemen. for being here today. I did have some questions around your interpretation of public interest, but I guess we heard a lot of concerns from community members in Collie when we were there last week around your company's commitment to the community, your investment in the community, claims around reduction of support for community organisations, etc. And I just wanted to give you a chance to clarify, is that the case? Because obviously in a rural community like Collie, your local industry supports for sporting clubs and community events is incredibly important.
It's a very fair question, and so I have no issue with it. Look, Griffin Coal would like to be part of the community, but it has to live inside the community with the constraints it has in terms of its operating. It has traditionally been involved with a number of initiatives, and I think recently, last year, it was involved with the Griffin Festival. There were some allegations that Griffin Coal was not sponsoring that and that Bendigo Bank actually moved in. The reality of the fact is, and I can tell you, that Griffin Coal contributed last year $45,000 to the Griffin Festival. And the festival was expanded and Bendigo Bank came in and offered to take up that expansion. So for the members of the people who were in Collie, that was not correct. There was another allegation that the Pensioners Club or the Cheerio Club, which is where they give lunches.
Is that the social club? I don't think
no, I'll come to the social club in a minute. This is where they have lunches for the local pensioners. I was approached by the CFMEU to make a contribution of $3,000, and I immediately authorised our people because we had historically done it, and it is a community-based issue to allow that expenditure to go, because clearly we have to have, we very carefully and tightly watch our expenditure. So that money was committed. I think, and I have a list here, but I'm happy to give you some numbers against it. Since 2012, Griffin has contributed in the following ways to the community of Collie. May I give you the list, sir?
Yes, certainly.
The South West Apprentice Awards, the Collie...
sorry, and Mr Gray, can I just clarify that these haven't been something you've done 2012 to 2015
Since 2012, and that's why perhaps I'll put some dates and some meat around the bones if that's the case.
Well, actually, I actually understand.
You have it here.
You've already provided that information to us, so we're nearly out of time. So, maybe the question really was, I think...
Just in conclusion to the answer, Griffin Coal is keen to be involved in the community, but there are constraints on what we can pay, because we have to balance what we put into the community in terms of donations with honouring our obligations, both to our employees and to our creditors as well.
Thank you.
Can I ask you why you ceased payroll deductions to the social club?
Well, because we had to put a new pay system in, and it's just another on-pass to us, so that's why it was done. There was a number of deductions that were taken off there, and we just didn't do them anymore.
So was there some discussion with the social club, or it just happened?
I'd have to take advice on that. It was done by... I'm not a micromanager, sir. I don't get involved at every level, but I could come back to you with an answer. But I think it was, in principle, we agreed because it's a cost in our organisation.
All right. Well, that does take us through to 6 o'clock, unless there was any urgent
I've certainly got... we didn't have time for me to conclude my questions, but I'm happy to put them on notice if you're able to answer those. We've been through some of them, but it would be good if you could respond to them.
What we have committed to answer, I'll certainly get back to you on, sir.
Yeah, I think Senator Pratt's indicating she's probably got half a dozen extra questions. Unless you wanted to go through them, no, senators have other commitments now. So if you'd be kind enough, if Senator Pratt puts them in writing to you, if you'd be kind enough to also respond to those.
If she would put them in writing, I'd be happy to respond to them.
Thank you, Mr. Gray.
Thank you. You'll get them from the Secretariat. Thank you.
Well, thank you. Thank you, Mr. Gray and Mr. Newmair, for your appearance, for your submissions and for your appearance before the committee today.
Okay, thank you.
Thank you.
I declare this meeting closed.